Hello and welcome to Dorsey and Whitney's M&A update. I'd like to introduce Brian Burke, a partner in Dorsey's Mergers and Acquisitions group. Brian?
Thank you, Rima, and thanks. Good afternoon to everyone who's on the line today. Appreciate you making the time to spend the next hour with us as we run through the January 2023 M&A update, which is our semi-annual look at corporate and alternative entity law developments of interest to the M&A practitioner. So as Rima said, my name is Brian Burke. I'm a partner here in our Minneapolis M&A group, and I'm joined as always by Amelia Messa, partner in our Delaware office, and John Van Horn, also a partner in our Minneapolis office. So we have, as usual, a lot of important developments to cover today. And so first, I'll turn it over to Amelia for the news from Delaware.
Thanks, Brian. So to get us started with some news from the court, our Justice Vaughn from our Supreme Court has announced that he's retiring from the bench effective May 1st. Justice Vaughn first joined the bench in 1998 as a Superior Court judge, where he eventually became president judge of our Superior Court. He then was elevated to the Supreme Court in October of 2014. Prior to joining the bench, he was a civil and criminal litigator for over 22 years. He's also an Army vet. He attended Duke for undergrad and Georgetown for law school. So we wish him all the best in retirement. We don't yet have any announcements as to who his replacement is going to be. And also notably, we're going to have another vacant spot as of February when Justice Montgomery Reeves moves up to the U.S. Court of Appeals. We also have some master in chancery news. So in addition to our chancellor and our vice chancellors, our chancery court also has what are called masters in chancery. They are absolutely crucial to our court. They hear cases that are assigned to them, focusing on guardianships, property disputes, trust and estate matters, but they will hear occasional entity disputes as well. They are a huge help with clearing out the huge caseload that our chancery court currently has. So on December 1st, the Honorable Patricia Griffin retired from the bench after serving 5 years as a master in chancery. And in some good news, we actually had some state funding to provide us with an extra master in chancery position, and the Honorable Lauren Mitchell joined the court. So we look forward to reading her opinions. In some good news out of our Secretary of State, I believe it was a year ago that we talked about how our Secretary of State was completely backlogged. Basically, any filing that you wanted to do, you had to pay for expedited service, but I am very happy to announce that they are back on track. Basic situation starting in October, the state temporarily suspended doing pre-clearances just to help them have more time to address the backlog. That suspension was supposed to last until February, but it was actually lifted in November because they were able to get back on track. I just confirmed this week that regular service is now taking 2 days. A year ago, it was taking months. So we're doing much better. I would say if you are doing a filing where timing is crucial, definitely check with your filing agent to see and make sure that the Secretary of State is still running on time. Plan for additional time. Use expedited service if you are doing a crucial filing, such as a merger or something like that. And of course, always get your filings right the first time so you can avoid having to do amendments and fixes, which add time and expense. So with that, we'll go to Brian for some discussion on our Supreme Court and appraisal rights.
Yeah, thanks, Amelia. So at the end of July last year, the Delaware Supreme Court addressed a case having to do with appraisal rights. And appraisal rights is an area of law which we've seen quite a bit of development over the last 10 years, much of which we've discussed right here in the M&A update. So to set the stage a bit, appraisal rights were first introduced in Delaware by the enactment of Section 262 way back in 1899. Prior to that, as hard as it is to believe, mergers required unanimous stockholder consent with the obvious problems that entails. So the appraisal statute fixed this by allowing mergers to go forward based on majority consent, while offering minority stockholders the remedy of having the Chancery Court determine fair value of their shares if they didn't agree with the merger. By the early part of the 21st century, however, enterprising activist investors enacted a strategy called appraisal arbitrage. So they found that they could acquire shares and demand appraisal, hoping that their experts could convince the Court of Chancery that fair value was far above the deal price. And it worked. So in response in 2017, the Delaware Supreme Court issued the DFC and Dell decisions, which moved to put an end to appraisal arbitrage. In those decisions, the Delaware Supreme Court made it clear the deal price minus synergies or the unaffected market price should normally be given the greatest deference in determining fair value for purposes of appraisal. Expert valuations, which frequently produce the jackpot valuations, are the exception now, not the rule. But even while this has curtailed the appraisal arbitrage's abuse of Section 262, appraisal remains an important remedy for minority stockholders who do dispute the merger consideration to which they're otherwise entitled. So that brings us to the latest Delaware Supreme Court case dealing with appraisal. Now, we actually first talked about this case a couple years ago at the M&A update when it made its way to the Chancery Court. And the key issue in the case that it deals with is the question, how are pre-closing dividends that are contingent upon closing treated for appraisal purposes? So first, some background. The case arose out of Brookfield's acquisition of GGP, one of the largest owners and operators of shopping malls in the United States. And the transaction had a very unique structure. Brookfield acquired GGP for a pre-closing dividend, which amounted to 98.5% of the deal consideration. And that was actually funded by Brookfield and made contingent upon the closing, as well as a merger consideration at the closing of 31 cents per share. Okay, so because Brookfield was a 35% stockholder, they used a special committee, GGP used a special committee to negotiate the transaction. And when put to a stockholder vote, the deal was overwhelmingly approved by the disinterested stockholders. So the unique structure of a pre-closing dividend appeared to arise as part of the negotiations over whether or not there would be an appraisal out condition. So Brookfield wanted the ability to terminate the merger if a certain threshold of shares demanded appraisal. GGP's special committee refused to accept that condition, and after conceding and giving on the appraisal out condition, Brookfield proposed the new structure of funding a large pre-closing dividend contingent upon closing to reduce the closing merger consideration. Now, importantly, the proxy here, which clocked in at an efficient 344 pages, not including the introductory letter, select definitions, or the various exhibits, explain the structure, but when advising stockholders of the right to seek appraisal, said that they could do so only in lieu of the per share merger consideration. As a result, the plaintiffs brought suit seeking quasi-appraisal damages, in part claiming that the proxy improperly indicated that appraisal only applied to the narrow per share payment of 31 cents per share and not the pre-closing contingent dividend. The plaintiffs also argued that this improperly dissuaded stockholders from seeking appraisal. Additionally, they brought claims against the GGP directors for their role in breaching fiduciary duties due to the deficient disclosure on the appraisal process, and brought claims against Brookfield, the buyer, for aiding and abetting that breach as well. So, as we discussed in 2011, this case first went before the Chancery Court. And Vice Chancellor Slides determined that payment of a pre-closing dividend does not violate the appraisal statute by moving deal consideration outside the ambit of the appraisal process. And when looking at the text of Section 262H, he found that the dividend itself is just a relevant factor in the appraisal analysis. To that end, he found that the proxy's notice of appraisal rights was sufficient, and so no claims from the plaintiffs survived. But on appeal to the Delaware Supreme Court, this decision was reversed in a close 3-2 opinion authored by Justice Traynor. The majority first held that a pre-closing dividend funded by the buyer contingent upon closing is more than just a relevant factor for appraisal analysis. Instead, he said, quote, dividends that are conditioned on the consummation of a merger are treated as merger consideration under Delaware law, meaning that the fair value of an entity that declares a conditional dividend is appraised as if the dividend had not been declared. So following along with this thinking, the court went on to clarify that unlike the general rule that acceptance of merger consideration waives a stockholder's right to appraisal, receiving a pre-closing dividend payment, even though that's considered part of the merger consideration, does not waive a stockholder's right to appraisal. And they distinguish this because this is a different situation than a traditional merger where stockholders can either elect to receive the merger consideration or elect to seek appraisal. Here, the dividend was paid to all stockholders, even dissenting stockholders, and so there's no choice in the matter. Second, the majority said that the proxy's description of appraisal rights was at best materially misleading. So the proxy here repeatedly said that appraisal rights were available in connection with the merger, and dissenters would be entitled to fair value for their shares in lieu of the per share merger consideration. Thus, the proxy tied appraisal rights to the 31 cents per share closing cash payment and not the substantial pre-closing dividend. On appeal, defendant's counsel offered to the court no business reason for why the consideration was split into a pre-closing dividend and a smaller closing merger payment. Justice Traynor found that in part because of this, the court thought that there was a reasonable inference that the purpose of the structure was to dissuade stockholders from seeking appraisal. Importantly, Justice Traynor also noted that the proxy's framing of appraisal as being for the smaller merger consideration of 31 cents per share also dissuaded stockholders because it called into question whether or not appraisal was available under the de minimis exceptions of Section 262G, which were put in place back in 2016. So under that, stockholders can't seek appraisal unless dissenters represent $1 million in merger consideration or 1% of the outstanding equity, and it's obviously harder to get to $1 million of merger consideration if it's only 31 cents per share that is subject to appraisal. Okay, therefore, the defendant's motion to dismiss was denied by the majority, and the directors will have to face claims for breach of the duty of loyalty and their disclosures, while Brookfield will have to face claims for aiding and abetting that breach. To offer a third opinion on what's actually happening here, though, Justice Montgomery Reeves dissented, joined by Justice Vaughn. And the dissent was notable for two reasons. First, they agreed with the majority that the contingent pre-closing dividend is part of the merger consideration, such that appraisal is to determine fair value without taking into account that dividend. But they said that doesn't make the proxy description here incorrect. Mechanically, since the dividend will have already been paid to all the stockholders, including dissenting stockholders, it's true to say that anyone seeking appraisal will receive the remainder of the fair value owed to them in respect of their shares as determined by the Chancery Court in lieu of the pre-closing merger consideration. So they would have affirmed the Chancery Court and dismissed the claim seeking quasi-appraisal and fiduciary duty breaches due to the defective disclosures. So slightly different opinion on a nuanced issue here, but the takeaway, as long as this is straightforward. Pre-closing dividends contingent upon the transaction and funded by the buyer are considered part of the merger consideration and should be described appropriately and carefully when giving stockholders notice of their appraisal rights. All right, that's enough on appraisal for today. Next up, I'll turn it over to you, John, for a discussion on fraud and the Avery Partners line of cases.
All right, thanks, Brian, and thanks everyone for joining us. Let's start by quickly reviewing a Leo Strine decision that we have discussed often in prior M&A updates, the cornerstone case of Avery Partners versus F&W Acquisition, LLC. In the Avery Partners case, then Vice Chancellor Strine described the tension between the strong American tradition of freedom of contract and a general public policy interest in creating disincentives to fraud. Here's where Strine landed. First, Avery Partners confirmed that extra contractual fraud, that is, fraud outside of the contract, can be eliminated by a clear contractual language stating that the buyer has not relied on statements made outside the contract. Contractual fraud, that is, fraud as it relates to representations made within the contract itself, may be limited or eliminated for negligent or reckless misstatements, but public policy requires that a party may not limit or eliminate its liability for knowingly false statements made within the contracts. Multiple cases since Avery Partners have upheld the proposition that a clear statement of non-reliance in the purchase agreement can effectively eliminate liability for extra contractual fraud. But how exactly does a non-reliance clause work? As we all remember from 1L year, reliance on a false statement made with an intent to deceive is one of the necessary elements of the tort of fraud. An effective statement of non-reliance eliminates the possibility of proving up this necessary element of the tort. Other cases have fleshed out some guardrails that define the outer limits of the Avery Partners doctrine. For example, many M&A agreements specify that contractual indemnification, which is often subject to negotiated limits like caps and baskets, is the sole remedy for breaches of representations and warranties. These exclusive remedy provisions, coupled with carefully drafted non-reliance provisions, may be effective in preventing or establishing limits on liability for negligence-based theories of fraud, such as equitable fraud or constructive fraud, but cannot be used to bar claims for deliberate fraud. Similarly, non-recourse language that is often included in M&A agreements to shield non-parties from liability is not an effective bar against claims of intentional fraud where it can be demonstrated that the non-party persons knew of the party's false representations. Got all that? Nor will express contractual language that a party's reps and warranties do not survive the closing prevent a post-closing claim for intentional fraud. That's the too much dynamite case that Brian described for us back in July. All right, in late 2019, a fund called Hudson Vegas Investment made a minority investment in a company called P3 Health Group. P3, that's a name you want to remember. In diligence, Hudson was provided with a set of projections that showed 2020 EBITDA coming in at about $13 million. However, no representations around the projections were included in the purchase price. Fast forward, following closing, the business brought home a nice fat negative EBITDA of $40 million in 2020. Hudson then sues everybody in sight, alleging fraud by P3, certain of its principal owners, and certain officers of both P3 and the principal owner defendants. So, good thing for the defendants that the contract included the non-reliance clause shown here, which says that neither the company nor any of its affiliates is making any representation or warranty with respect to the company, including with respect to any projections, except for the reps and warranties set forth in the contract. Remember, no reps and warranties around projections were included in the purchase agreement. So everyone's off the hook, right? Or should the defendants be just a wee bit worried about the vaguely defined fraud carve-out shown in red? Oh yeah, I'd say so. Vice Chancellor Laster found that the carve-out in the last sentence operated to allow the buyer to make claims that it had reasonably relied on fraudulent statements made outside the contract, like, for example, the projections. But what about the non-recourse provision? Doesn't that at least insulate the principal owner and its officers from the claims of fraud? Nope. Remember Online Health Now? That's the too much dynamite case. One of its holdings is that a non-recourse provision will not insulate third parties from liabilities if they facilitated the contractual parties' lies in the context of intra-contractual fraud. Remember, that's the kind that can't be contracted out of, intra-contractual fraud. Here, Laster extended that holding to extra-contractual fraud that has not been taken off the table by an effective non-reliance clause. As a result, motion to dismiss is denied. The next case is a further endorsement of the holding in Online Health Now. Here, buyer brought post-closing claims of intra-contractual fraud against the seller, who was the contract party, and certain non-party affiliates of the seller, obviously not parties to the contract. In the non-reliance provision included in the contract, buyer expressly disclaimed any reps and warranties other than those included in the contract, which were exclusively made by the seller. The non-recourse provision contained customary language exculpating third parties from liability, as well as a specific affirmation that none of a long list of non-party persons had made any reps or warranties in connection with the transaction. So does this combo get the non-parties off the hook for claims of intra-contractual intentional fraud? No, not if such parties have been knowingly complicit in the contracting party's fraudulent representations. The bounds of the non-recourse protections are set by the limits that every partner sets on the contract parties themselves. Just as a contract party may not contract out of intentional fraud with respect to intra-contractual representations, a non-recourse provision does not shield non-parties from liability for their knowing participation in that intentional fraud. So, where does all this leave us? A set of well-drafted contractual provisions can insulate both contract parties and their non-party affiliates from liability for claims of extra-contractual fraud. On the other hand, there is no contractual mechanism that will effectively eliminate the possibility for liability for intentional intra-contractual fraud. This is equally true of contract parties engaging in intentional fraud and of any non-party persons who knowingly participate in the fraud. But as the P3 case again illustrates, one of the keys here is precision in the contract language. The Delaware courts are awfully fond of reminding us that there are multiple ways of expressing the clear intentions of transaction parties. These statements of the court usually incorporate the phrase magic words, as in, there are no magic words required for a particular result. That said, some words are clearly more magical than others. Intra-contractual fraud, extra-contractual fraud. It's easy to get lost in here. And the best and admittedly self-serving lesson is to make sure you have a reliable guide when navigating this forest. Now, remember when I told you to remember P3 Health Group? Over to you, Amelia, for another case involving P3.
Thanks, John. Yep, so now we're going to talk about P3 and a merger that it did with a SPAC. So in this case, our merger is challenged in many different ways, mainly under P3's LLC agreement, because it's a Delaware LLC, by Hudson, the minority investor that John mentioned earlier. Here, P3's controlling investor, Chicago Pacific, was really the one who negotiated and came up with the structure for the merger. Notably, the initial structure that it came up with was scrapped because it would have required minority approval, and Hudson was going to refuse. So in looking at the various claims that Hudson makes, first, it claims that there was a breach of the LLC agreement of P3 by both the SPAC and Chicago Pacific. The court easily dismisses this against the SPAC because the SPAC is not a party to the LLC agreement. It also dismisses this claim against Chicago Pacific because in its capacity as a member, it did not owe any of the obligations that Hudson is trying to enforce. Everything that Hudson was trying to argue here was really against the LLC or P3 itself. Next, Hudson claims that there was a breach of the LLC agreement because post-merger in the survivor, Hudson was no longer entitled to appoint a manager, whereas it had that right under the P3 agreement. This one is also dismissed. The court says, I'm sorry, but once that merger happens, you as a member can no longer exercise your rights that you had in the LLC pre-merger. Hudson also claims, hey, there was a breach of the LLC agreement because the board size of the survivor is less than the board size of P3. Again, the court dismisses this and says that under the P3 LLC agreement, the term board simply means the board of P3, not the board of the survivor. So next, Hudson tries to claim that there was a breach of the LLC agreement because it was entitled to consent to this merger because it was an affiliated transaction under the terms of the LLC agreement. Here, the court's willing to go along with this. They said that, yes, it might be conceivable that the merger transaction, when looked at as a whole, could be viewed as a series of transactions that constituted an agreement to enter into an affiliated transaction. So here they allowed this claim to survive the pleading stage. Next, Hudson claims that we have a breach of the LLC agreement because the consideration it received in the merger did not comply with the distribution waterfall. Now, normally when we're looking at merger consideration, it doesn't typically go through a distribution waterfall for an LLC. But here, our LLC agreement specifically provided that when dealing with a reorg, it would go through the waterfall. So first, Hudson tries to say that it was entitled to cash, but the court says, no, I'm sorry, the LLC agreement does not require this. So that claim's dismissed. Next, Hudson argues that the amount that it received was not the full amount that it was entitled to due to some valuation issues. This one, the court does allow to survive the pleading stage. Finally, Hudson challenges the merger under the breach of the implied contractual covenant of good faith and fair dealing. So that's our gap billing concept that applies to every Delaware contract. Here, Hudson tries to assert that the implied covenant should come into play where it had a preemptive option that applied whenever P3 sold equity securities. It thought that it should apply because a SPAC merger, in essence, is a capital raise. The court here disagrees. It does, in fact, find a gap in the contract with respect to whether a de-SPAC merger is an equity capital raise. But when the court looks at the LLC agreement and finds that it did contemplate a traditional IPO, which the court analogizes to a de-SPAC merger, and finds that with an IPO under the LLC agreement, it was not viewed as an eligible capital raise, triggering the preemptive option. And therefore, the court thinks that had the parties negotiated the issue of a de-SPAC merger when they were drafting the LLC agreement, they most likely would not have treated the merger as a triggering event for the preemptive option, and therefore that claim's dismissed. Finally, Hudson argues that its managers did not receive all of the information that all of the other managers received and were frozen out of the process, and this too is a breach of the implied contractual covenant. Here, the court also finds a gap. There's no express requirement in the LLC agreement that all managers should be provided with the same information. But here the court analogizes P3's board of managers with the board of a Delaware corporation, and finds that, in fact, there is harm in not providing all of our directors or managers here with all information. The court finds that our Hudson managers could have negotiated better terms in the deal, or at least had a voice at the table. So with that, I will pass us on to John, who's going to talk about non-competes.
All right, thanks, Amelia. And now I'm hungry for lunch. Restrictive covenants are frequently used by buyers as a means to protect the goodwill, intellectual property, and key commercial relationships of an acquired business. We M&A practitioners frequently view enforceability of restricted covenants through the lens of state laws, which vary in their treatment of such covenants. It is important, however, not to lose sight that there is a federal law overlay to the subject matter that derives from the Sherman Act, the Clayton Act, and the Federal Trade Commission Act. In June of last year, the FTC challenged the non-compete covenants entered into in connection with the sale of 60 gas stations by Corrigan to an affiliate of ARCO. The non-compete prohibited the seller from engaging in competitive business not only in the geographies where the 60 sold stations were located, but also in an additional 190 locations where the buyer operated gas stations, but the seller did not. The parties ultimately entered into a consent agreement, which, among other matters, narrowed the geographic scope of the non-compete to territories within 3 miles of the acquired stations and limited the duration of the non-compete to 3 years. In a more recent development, the FTC proposed a new rule to ban employee non-competes outright. The proposed rule contains an exception for non-competes entered into by employees in connection with the sale of a business. This exception will be familiar to those of you with expertise on the various state laws governing non-compete covenants. Many of them contain similar exceptions. The exception in the newly proposed rule would apply only to employees who are owners of an interest of 25% or more in the acquired business. As many of you know, many buyers today seek to sign up key managers of acquired businesses with equity stakes well less than 25% to non-compete covenants. So if adopted in its present form, the rule would likely precipitate widespread changes in the approach to tying up management of acquired businesses. That said, the rule is in the early days of the rulemaking process and is expected to face substantial opposition. We will keep you updated as the new rule makes its way through the administrative rulemaking process. Returning to the more familiar ground of state law cases interpreting non-compete covenants, I'll hand it over to Brian, who will review 2 recent Delaware cases addressing the subject.
Thanks, John. Yeah, so against that backdrop of the FTC taking a closer look at the enforceability of non-competes, we actually had 2 very important Delaware cases dealing with non-competes as well. The first of which is Kodiak versus Adams. So to give a little background, Kodiak was a diversified building materials manufacturer and supplier, and it acquired Northwest Products, a manufacturer and seller of roof truss building products based in Rathdrum, Idaho, right on the Idaho-Washington border. And Philip Adams was a former 8.33% shareholder and general manager of Northwest Products. and he received about $900,000 in the sale in consideration of his equity. Along with Northwest's other 3 shareholders, the 4 of them entered into restrictive covenant agreements in favor of Kodiak at the time of the transaction. However, after the closing, about a year later, during the restricted period, Adams left and went to work at a competing roof truss supplier, just 24 miles down the road from where he used to work, and he promptly started winning customers to his new employer over Northwest products. So naturally, Kodiak was a little upset that they bought this business, paid Philip Adams $900,000, only for him to go down the street and start competing. So they sent a cease and desist letter. Hearing no response there, they sought a preliminary injunction on Adams' activities for the competing building truss supplier from the Chancery Court. This is the non-compete provision at issue. The non-compete, and I've excerpted it from the case, so this includes the emphasis that was provided by the court. The non-compete covered two things are important here. First, geographically, the non-compete, similar to what John just talked about in the Corrigan and Arco case that the FTC said, applied not only to Idaho and Washington, where Northwest did its business, but it also included a scope covering a 100-mile radius around any of the buyer's locations. And furthermore, the scope included not just the business of Northwest, but also it prohibited the sellers, including Philip Adams, from conducting any business which competed with any of buyers' lines of business, which were much broader than what Northwest did. Similarly, in the non-solicitation provision, Adams was prevented not only from soliciting current customers or current clients of Northwest, but also was prevented from soliciting customers and clients of the buyer. So this went before Vice Chancellor Zurn, and she looked under Delaware law and looked at the 3-factor test that courts use when evaluating non-competes and non-solicits in Delaware. First, they must be reasonable in geographic scope and temporal duration. Second, the restrictions must advance a legitimate economic interest of the party seeking its enforcement. And third, they must survive a balancing of the equities between the parties. So moving on to the analysis here, she first looked at the contract and saw that in the restrictive covenant agreement, as is common, Philip Adams and the other stockholders stipulated that the restrictions were reasonable and necessary to protect buyers' interest in the transaction. The court said that doesn't matter. Such stipulations are against public policy. They don't bind the court on what those determinations are. And so we'll move on with the analysis ourselves. Conducting its own analysis, the court found that there was not a legitimate economic interest here. Kodiak, the buyer, had a reasonable interest in protecting the goodwill of Northwest that it acquired. It did not have a reasonable interest in protecting its pre-existing business. The court also found that the scope was not reasonable. The geographic scope was too broad as it included geographies around any buyer location. And the non-solicit was too broad in that it covered buyers, customers, and suppliers instead of just the targets. And third, the balance of equities favored Adams. This is interesting. So although Adams did go to work for a competitor, selling the same products to the same customers just 24 miles away from where he used to do it, the court found that it would be inequitable to enforce an unreasonably broad restrictive covenant agreement against him. Therefore, the restrictive covenants were found unenforceable and the preliminary injunction was denied. Now, one important question that Vice Chancellor addressed was whether blue penciling was an option to save the non-compete here. And to that, she said no. She said, quote, "The inequities inherent in blue penciling a non-compete also counsel against enforcing only those portions of the restrictive covenant agreement that are supported by Kodiak's legitimate business interests, even as Adams appears to have violated those portions. Therefore, the preliminary injunction was denied, even though the court acknowledged that if the parties had appropriately drafted the non-compete, it would have been used to enjoin Adams' behavior." So the second case in Delaware decided just earlier this month is Ainsley versus Cantor Fitzgerald, which also arose, dealt with non-competes, also a decision of Vice Chancellor Zurn. This time it arose in the context of a partnership agreement. So former partners of Cantor Fitzgerald were subject to a 2-year restrictive covenant agreement extended to 4 years, where they would forfeit provisions for repayment of their capital accounts if they violated the restrictive covenants. So in the case, 6 former partners from Cantor Fitzgerald Hong Kong, an affiliate of Cantor Fitzgerald LP, left and they violated the restrictive covenants and were denied payment of their capital accounts. So Vice Chancellor Zurn again found that the restrictive covenants were unreasonable and unenforceable. The restrictive covenants here she found were so overbroad because they're worldwide in scope. They covered all the affiliates of Cantor Fitzgerald, all employees and customers of affiliates, any activities competitive with any affiliate of Cantor Fitzgerald. They were so broad that the court found that under these standards, it is highly possible that a partner could unknowingly engage in a competitive activity. So once again, she declined to blue pencil the restrictive covenants, even where the alleged competitive activities here would have been within the scope of an enforceably drafted non-compete. So one note here is that under the FTC rule that John just talked about, the non-compete here would have been banned, as would the non-compete as to Adams and Kodiak, which was under the 25% threshold that he mentioned. So it remains to be seen what the FTC overlay has to do with these types of cases. But regardless, these two cases go to show that even in the contractarian state of Delaware, it's taking a much harder look at non-competes, and buyers should be careful not to ask for too much and risk having their non-compete be entirely unenforceable. So with that, Amelia, I'll send it over to you for choice of law.
Thanks, Brian. So really just a continuation of our restrictive covenant discussion and how choice of law comes into play. So as John mentioned, there's a number of states, including California, that have restrictions or complete prohibitions on certain restrictive covenants. This is oftentimes due to public policy consideration. Delaware, on the other hand, does tend to favor principles of freedom of contract, and such provisions are generally more enforceable. That is with the caveat of, those cases that Brian was just discussing, where Delaware does in fact have some limits. We don't allow overly broad or unjustifiable covenants. But in general, Delaware will actually take a look at them, and they are more likely to be enforced there as opposed to the states which outright prohibit them. So to get around states like California's restrictions, parties will sometimes opt to govern their documents, such as employment agreements and other contracts, by Delaware law, which was what the case was in Parks versus Horizon Holdings. So in this case, it involved the sale of a family boat building business that was located in Oklahoma. There were various contracts involved, many of which contained restrictive covenants, and they purported to govern them by Delaware law. The sellers of the business then went on to start a pool manufacturing business. So those sellers are the plaintiffs in our current case, and they are seeking a declaratory judgment that the restrictive covenants are not going to be enforceable against them because they are Oklahoma residents, and under Oklahoma law, they should be void due to Oklahoma public policy. So the court here pulls apart all of the different covenants. First, on the covenants not to compete, it finds that there is no competition going on, so the court refuses to address this one. With respect to the non-solicitation covenants, the court finds that they would be enforceable both under Delaware and Oklahoma law, so there's no reason to change the choice of law from Delaware. And finally, the court looks at the covenants not to interfere with supply chain usage in the business that was sold, and the non-solicit and non-interference of marketing covenants. So we'll call those the remaining covenants. These notably were all contained in an LLC agreement for a Delaware LLC that was set up to facilitate the sale transaction. So these covenants are applicable here because the plaintiff's new pool company was using common suppliers as the defendant's then boat building business, and there was also some overlapping marketing going on. So to do the choice of law analysis, the court does the following. In step one, it looks to see, is there an actual choice of law conflict? Step two is, if there is a conflict, the court then applies the restatement second of conflicts of law, and there it determines whether the second state's laws should supplant the expressly chosen laws of the state of Delaware. It looks particularly at which state has a materially greater interest in the enforcement of the restrictive covenants. So here, in step one, is there an actual conflict between Delaware and Oklahoma law? And yes, there actually is. So Delaware most likely would enforce these types of restrictive covenants, but based on Oklahoma public policy, these covenants would be void. So we meet step one, there is a conflict, and so we move on to step two. Under step two, the selected law of Delaware will apply unless under the restatement, either A, the Delaware has no substantial relationship to the parties or the transaction, or B, application of Delaware law would be contrary to a fundamental policy of a state which has a materially greater interest than Delaware in the determination of a particular issue. and which would be the state of applicable law in the absence of an effective choice of law by the parties. So starting with Part A here, in this case, we were dealing with an LLC agreement for a Delaware LLC. So clearly Delaware has a substantial relationship with the LLC. So A is covered. So then the court moves on to prong B. Here, the court looks at a number of different factors to determine which state has the most significant relationship to the factors. These include the place of contracting, place of negotiation of the contract, place of performance, location of the subject matter of the contract, as well as the location of the parties. So when we apply those factors to our Parks case here, first, the court looks at the fact that the LLC agreement was negotiated and executed in Oklahoma, not Delaware. However, the court finds that standing alone, this is not going to be enough to change the choice of Delaware law. And if you think about it, that makes sense because really almost all Delaware LLC agreements are not actually negotiated or executed in the state of Delaware. The court next looks at factors relating to the place of performance and finds that this is inconclusive because the contracts were not performed totally in Oklahoma. It also finds that the parties involved lived in multiple states, so this factor also was inconclusive. So in putting all the factors together, the court finds that there was no showing as to why Delaware law should not apply to the contract. I think another key factor here was we are dealing with an LLC agreement for a Delaware LLC, not a separate employment contract. So our holding is that Delaware law sticks, it applies. But the takeaway here is that every case and contract is going to be different. Our courts follow a restatement analysis with many different factors in a very fact-intensive analysis. Selecting Delaware law can be a way to get around local laws that would otherwise prohibit restrictive covenants. However, you really do need some hook or connection to Delaware, again, going back to those factors that we discussed. Notably here, the court failed to address that under 181101I of our LLC Act, an LLC agreement that provides for the application of Delaware law shall be governed by and construed under the laws of the state of Delaware in accordance with its terms. So I think had the court actually looked at that section of the statute, it probably would have been able to avoid the entire restatement analysis. So with that, we will go to Brian for the most important part today, the CLE code.
Yeah, thanks, Amelia. All right. Next up, we have a quick antitrust update for you. So earlier this week, on Monday, actually, the FTC announced annual increases to the HSR reportability thresholds. Now transactions less than $111.4 million are not reportable. It's a little bit higher than it used to be. Transactions between $111.4 and $445.5 million may be reportable based on the size of persons test, and transactions greater than $445.5 million are reportable. Also, as was previously reported on December 29th, HSR filing fees are changing for the first time in over 20 years. So currently the filing fees range from $45,000 for smaller transactions up to $280,000 for the largest transactions. Now the range, however, will be between $30,000 and $2.25 million. So some transactions will actually be a little bit less expensive to file, but large transactions will be significantly more expensive. In each case, revisions will take effect 30 days after publication in the Federal Register, which we expect shortly. All right, next we have a very quick case for you dealing with the question of what is a change of control. And that is the Johnson Revocable Living Trust versus Davies case. So the background here, sellers sold their business, Johnson Claim Services, to Davies US pursuant to a stock purchase agreement. And in that agreement, a portion of the consideration was deferred with the provision stating that it would accelerate upon a change of control of the company, Johnson Claim Services. In 2021, a year later, BCP acquired Davies Topco Limited, which controlled Davies Group Limited, which controlled Davies US LLC, which owned the company. And sellers argued that this was a change of control of the company requiring acceleration of their deferred consideration. Now, change of control was defined in the agreements excerpted here, and it was defined to mean any of the following, directly or indirectly, including a sale of 50% or more of the equity ownership or voting power of the outstanding capital stock of the company. Now, Davies argued that it's quite clear that in this transaction, that definition is not met. The owner of the company is still Davies US LLC that controls all the voting power of the company, and there's no change. However, the court said no, an indirect ownership transfer by sale of the ultimate parent entity is sufficient to qualify as an indirect change of control under the definition, so motion to dismiss is denied. All right, Amelia, we have a couple other updates from the alternative entity case law world that are important for our listeners to know. So I'll turn it over to you.
Thanks, Brian. So yes, just a couple of alt entity updates here. First, dealing with void transfers. So here what we're talking about are LLC agreements that contain the provision that provides that when conditions or requirements to a transfer are not complied with, the transfer is going to be considered void ab initio, language like that. It's really common to see these types of provisions, especially in heavily negotiated LLC agreements. And under existing Supreme Court case law in Delaware, it's been made clear that void transfer provisions are going to be enforced and no equitable exceptions will apply. So here, Vice Chancellor Laster gets his chance to weigh in XRI Investment Holdings, LLC versus Holyfield. In this case, we have a member who transferred its interest in the LLC in violation of the LLC agreement. Here, our LLC agreement contained that type of provision that provided that transfers that violated its agreement were going to be void ab initio. The interesting thing in this case was that the other members at the time of the transfer were not just fine with the transfer, they actually helped to make the transfer happen. So they make the transfer happen, and then some time passes, and then those other members decide that it would actually be beneficial for them to challenge the transfer and engage in a strict foreclosure. So when the transfer is challenged, an argument is made that the equitable doctrine of acquiescence should apply based on those other members really helping to even make the transfer happen. Vice Chancellor Laster says, "I'm really sorry, I wish it didn't have to come out this way, but the transfer is void." He says he's bound to follow Supreme Court precedent here. He then provides many pages of dicta, as he does, and he provides his views as to the fact that a court of equity should be able to help in this type of situation. He then lays out in a lot of detail all of his reasoning for why and how the Supreme Court should overturn its prior precedent. He basically feels that incurable voidness should be reserved for things that violate limitations that the state has imposed and not contractual limitations. But we'll have to wait and see if this case is appealed. And for now, if you say void in your LLC agreement, it really is going to mean void and the courts cannot help you. A quick note on personal jurisdiction. So unlike corporations, LLCs do not in the statute provide for officers. So to the extent that you have an LLC and you would like officers, you have to contractually create them, either in resolutions delegating authority to them or in your LLC agreement. So because the LLC Act doesn't talk about officers, it does not provide anywhere that officers are going to be subject to jurisdiction in Delaware for things that they do in that role. What we do have is section 18109A of the LLC Act that establishes the mechanism to serve process on a manager of an LLC. And it also contains some broad kind of catch-all language that it also applies to anyone who participates materially in the management of the LLC. So back to our P3 case again, the court addresses two different actors in the case. First, the court looks at the general counsel and chief legal officer and finds that she was considered a senior officer of the LLC. And in that role, she participated materially in the management of the company and therefore was going to be subject to jurisdiction under that 18109A catch-all language. I think the more interesting one was our second individual who was not a manager and was not even an officer of the LLC, but was a principal of the controlling member. The court here finds that he also fits into 18109A. Here, he had participated very heavily in the merger that we talked about earlier. He made decisions on behalf of the LLC, directed management, instructed advisors, and I think the real nail in the coffin here was the fact that he called and berated and really just yelled at the LLC's outside counsel for not sending him LLC documents that even the managers had not all received. So the court there says that he's completely comfortable finding that this individual is in fact a de facto manager fits within that catch-all in 18109A, can be served with process and subject to jurisdiction in Delaware. So now I'm going to turn it back over to John for what we've all been waiting for, and that's the update on Elon Musk and Twitter.
Thanks, Amelia. When we last gathered in July, we discussed season 1 of Silicon Valley's hottest soap opera. We watched as the world's richest man agonized over his most cherished plaything and constant companion, Twitter. Should Elon join Twitter's board of directors or not? Answer, no. Well, at least not in the way the parties contemplated back in April. Would Elon commence a hostile takeover of Twitter? Answer, he didn't need to. After announcing his intention to acquire Twitter, Elon and his advisors were able to assemble a credible financing package over the course of a whirlwind weekend in April. This brought Twitter to the bargaining table, and the parties entered into a definitive agreement for Elon to acquire Twitter for $44 billion. Hey, it's looking like these two crazy kids are going to make things work after all. But wait, here come the bots. Less than a month after announcing his entry into the merger agreement, Elon got cold feet and started publicly walking back the deal, citing concerns over the number of spam bot accounts on the platform. Finally, in early July, Elon formalized his attempt to blow up the deal and was sued by Twitter in Delaware Chancery Court. Also back in July, we talked about now Chancellor McCormick, who would be presiding over the case, her opinion from the Snow Phipps versus K-Cake case, and pondered the following cliffhanger. Was Elon using the purported termination as a tactic to reduce the purchase price in light of a broad-based sell-off in tech stocks over the summer? If so, would the Twitter board capitulate, even despite having the advantage of what appeared to be a strong legal position on the merits? If the case progressed to a conclusion, would a straightforward application of the Snow Phipps case lead to a slam dunk victory for Twitter, in which Elon would be ordered to specifically perform his obligations to purchase Twitter under the original merger agreement terms? Or would the debt financing that had so suddenly materialized in April evaporate, paving the way for Elon to validly terminate the merger agreement and walk away with only the obligation to pay the $1 billion reverse termination fee? Or would Elon, the ultimate disruptor, go rogue, defying a court of chancery order to either close the deal or pay the RTF and blow up Delaware's brand as a stable, predictable enforcer of arm's length contracts negotiated by sophisticated parties? Season 2 opened with the release of 151 private emails and text messages sent to and from Elon's phone, produced as part of pretrial discovery. Among the highlights here was the revelation that Elon's iPhone contact card for Twitter co-founder and former CEO Jack Dorsey refers to him as Jack Jack, and Elon's epic slapdown of a tech bro buddy for soliciting so-called randos to co-invest in Twitter equity. Now, this latter message might seem a little harsh, but the communications also reveal dozens of unsolicited direct offers to Elon to co-invest by some of Silicon Valley's most legendary investors. These offers included, quote, 250 million with no additional work required, and $1 billion, ... or whatever you recommend. There is even a cameo appearance by Sam Bankman-Fried, who, unbeknownst to us at the time, was auditioning for a reboot of Orange is the New Black. In the midst of this spectacle, Twitter stockholders quietly approved the merger agreement. Then, the plot twist. On October 4th, on the eve of a trial scheduled to begin the following week, Elon's lawyers sent to Twitter a letter in which Elon announced that he was prepared to proceed to closing on the deal's original terms, pending receipt of the debt financing and conditioned on the adjournment of the rapidly approaching trial. On October 6th, Over Twitter's objections, the chancellor notified the parties that based on Elon's statement that he expected closing to occur on or about October 28th, the litigation would be stayed until exactly 5 p.m. on October 28th. On October 26th, Elon strolled into Twitter headquarters carrying a kitchen sink. The transaction officially closed the following day. Elon promptly declared himself chief twit and began his overhaul of Twitter by firing Twitter's top executive leadership. With season 2 of Elon's Twitter saga concluded, what will season 3 bring? For starters, this transaction has quickly inserted itself into the GOAT discussion for worst M&A transactions of all time. Jordan or LeBron, AOL, Time Warner, or Twitter? Only time will tell. In early January, less than 6 weeks after the closing, Fidelity, one of Elon's non-rando co-investors, wrote down its investment by 56%, implying that the equity acquired for $44 billion in late October was now worth less than $20 billion. Many observers take a grimmer view than that, with some asserting that Twitter's equity value has been nearly destroyed. It has been reported that daily revenue at Twitter, which generated more than $5 billion in revenue in its last full fiscal year as a public company, has declined by as much as 40% since the acquisition, as large advertisers have slashed their spending on the platform. The next significant legal developments at Twitter could involve Twitter's debt. The first interest payment on the $13.5 billion debt package is due this Friday. Elon himself has publicly raised the possibility of a Twitter bankruptcy. Twitter recently held a yard sale, auctioning off artifacts from its headquarters, like a statue of its Bluebird logo and its espresso machines, and has stopped paying rent to some of its landlords. Finally, there's the Tesla effect. Tesla stock dropped 65% between the January disclosure of Elon's interest in acquiring Twitter and the end of the year, with a significant portion of that decline happening between the closing of Twitter, the Twitter transaction, and year end. Now, the cautionary caveats about the distinction between causation and correlation, as always, apply here. But there are many in the tech investing world that are worried that Elon has either lost his Midas touch, or even worse, that his management of Twitter could adversely affect the performance of the other companies with which he is involved. Coincidentally, as recently as yesterday, Elon testified in a class action lawsuit brought by Tesla stockholders centered on his ill-fated consideration of taking Tesla private, in which he famously conducted a public will he or won't he dialogue with himself on Twitter. You cannot make this stuff up. One final note, if you're looking for an unequivocal winner in this saga, you need look no farther than the obvious and correct choice, Twitter's public stockholders, who were cashed out at a $44 billion valuation amid a tech stock meltdown. Deal certainty is another clear winner. Finally, although the case did not ultimately go to trial, it is a clear feather in the cap of Chancellor McCormick. She demonstrated a steady hand in her role, which was part jurist and part circus master. I have no doubt that the prospect of suffering a humiliating defeat in litigation based on the Chancellor's clearly articulated jurisprudence from Snow Phipps was a major factor in forcing Elon back to the table and concluding a transaction he clearly would have preferred to avoid. The Chancellor's star is definitely on the rise in Delaware. Those of you wanting to keep tabs on our current activities might monitor a case proceeding in Chancery, which also involves a notoriously polarizing, high-profile business figure and comes with bonus upside entertainment value that might land that case in the mainstream business press or even the gossip pages. Whatever happens, we'll be here to report on it in July. I'd like to thank Brian and Amelia. It's been fun working with you on this. I want to thank our Dorsey U crew and tech crew for making this all happen. And to all of you out there, thank you for joining us. We hope to see you soon.